Welcome back to the High Court Report. Today we dive into a case that could reshape how investors challenge fund management decisions. FS Credit Opportunities Corp versus Saba Capital Master Fund.
This case packs a punch. The Supreme Court will decide whether investors can sue investment funds directly in federal court when those funds adopt policies that allegedly violate federal securities law. And the stakes extend far beyond these specific investment funds. This decision will determine whether activist investors get powerful new tools to challenge fund management, or whether the SEC maintains exclusive enforcement authority over most securities violations.
The apex tension revolves around something courts call implied private rights of action. Basically, whether Congress intended to let private parties sue to enforce a particular law, even when Congress never explicitly created that right.
Think about it this way. Congress writes laws that say, don't do X. But sometimes Congress forgets to specify who can sue if someone does X anyway. Courts then have to figure out whether they can create lawsuits that Congress never explicitly authorized.
Before we get started, I want to broadcast that we'll host our first ever High Court Report mailbag episode on Black Friday, November 28th. I'm really excited about the chance to interact with you, the audience. This term delivered blockbuster after blockbuster. You've got questions, you've got theories about how these cases connect. You want to know what I'm watching for in oral arguments or which decisions could ripple through your practice area.
Send your questions and comments by Monday, November 24th. Email us at scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. I'll read your message on air and dive deep into the answers. What's your take on this term's biggest constitutional battles?
Okay, let's talk about FC credit. So here's the question the Supreme Court will answer. Whether Section 47B of the Investment Company Act of 1940 gives private plaintiffs a federal cause of action to seek rescission of contracts that allegedly violate the Act. Let me read you the key statutory text that everyone's fighting over. Section 47B2 states, "Any provision of a contract shall involve rescission at the instance of any party to such contract."
Wait, so you're telling me this whole case turns on the phrase rescission at the instance of any party?
Exactly. Saba argues that phrase creates individual rights. It explicitly mentions any party seeking rescission. But FS Credit argues the provision just tells courts what remedy to apply when someone else brings lawsuit, not who can bring lawsuits in the first place.
That's a fascinating distinction. The text describes a remedy, but doesn't clearly create the right to seek that remedy in federal court.
And here's what makes this particularly tricky. Section 18I of the Investment Company Act requires that every share of stock shall constitute voting stock and have equal voting rights with every other outstanding voting stock. The question becomes, if funds violate that rule, who gets to sue them?
Let's tell the story from the beginning. We have 4 closed-end investment funds. Think of them as investment companies that issue stock once and then trade those shares on exchanges like regular corporate stock. These funds target long-term investors, especially retirees who want steady dividend income. But they attracted the attention of Saba Capital, which describes itself as an activist hedge fund that identifies underperforming funds and pushes for management changes. Now here's where things get spicy. These 4 funds traded at significant discounts to their underlying asset values, sometimes 26% below what their investments were actually worth. That signals serious management problems.
So Saba started buying shares in these funds, planning to accumulate enough ownership to force management changes. But the funds fought back by adopting something called the Maryland Control Share Acquisition Act.
This Maryland law strips voting rights from any shareholder who acquires 10% or more of a company's shares, unless 2/3 of other shareholders approve restoring those voting rights.
Essentially, the funds created a poison pill defense. Once Saba hit 10% ownership, they'd lose voting rights on all shares above that threshold, making it nearly impossible to challenge management.
Saba sued, arguing this violates Section 18 Harn's requirement for equal voting rights. But here's the procedural twist. They sued under Section 47B, claiming it gives them a private right to seek rescission of the fund's control share provisions.
The district court in Manhattan granted summary judgment for Saba following Second Circuit precedent in Oxford University Bank versus Saba Feeder. That 2019 decision held that Section 47B does create an implied private right of action. But the Third and Ninth Circuits reject that interpretation, creating a clear circuit split. The Second Circuit affirmed without addressing the private right of action issue since it remained bound by Oxford University Bank. The Supreme Court granted certiorari to resolve this circuit split and determine whether Section 47B actually creates private enforcement rights.
FS Credit makes three main arguments, and their first one goes straight to constitutional separation of powers. They argue that courts usurp legislative authority when they create private rights of action that Congress never explicitly authorized. They point to Alexander versus Sandoval, which established that courts must find clear congressional intent in statutory text and structure before inferring private rights. No more guessing about what Congress probably wanted.
Right, and they argue Section 47B contains zero rights-creating language. The provision focuses on what courts should do when enforcing contracts, not on who gets to bring lawsuits in the first place.
Their second argument relies on statutory structure. They point out that Congress knew exactly how to create private rights when it wanted them. It did so explicitly in Sections 30H and 36B of the Investment Company Act.
Those provisions create specific private rights to sue for damages in narrow circumstances. FS Credit argues this proves Congress intended the SEC to handle enforcement for everything else. Their third argument focuses on practical consequences. They claim implied private rights would disrupt the SEC's comprehensive regulatory scheme and enable short-term activists like Saba to hijack funds designed for long-term investors.
Saba fires back with their own textual argument. They emphasize that Section 47BI2 explicitly references rescission at the instance of any party, language they describe as indisputably rights-creating and individual-centric. They distinguish this from the generic regulatory language in Sandoval, arguing that Section 47B doesn't just tell the SEC to create rules, it explicitly envisions individual parties seeking relief from illegal contracts.
Saba's second major argument relies heavily on Transamerica Mortgage Advisors versus Lewis, known as TAMA. In that 1979 case, the Supreme Court found an implied private right of action for rescission under a different securities law provision.
They argue TAMA directly supports their position because both cases involve limited rescission remedies rather than broad damage claims. They contend that rescission represents a fundamentally different type of relief that doesn't raise the same policy concerns. And here's their policy counterpunch. Saba argues they actually serve beneficial functions by identifying mismanaged funds and forcing accountability. They point to these funds' poor performance and excessive fees as evidence that activist intervention helps shareholders.
The Solicitor General supports FS Credit with three key arguments. First, they emphasize modern Supreme Court precedent strongly disfavors implied private rights of action. They argue courts should apply Sandoval's strict textualist approach and refuse to infer rights from ambiguous statutory language. When in doubt, don't create new federal lawsuits.
Second, they make a structural argument about the Investment Company Act's comprehensive enforcement scheme. Congress created limited private rights in two specific sections while giving the SEC broad enforcement authority everywhere else.
Their third argument directly challenges the Second Circuit's reasoning in Oxford University Bank. They argue Section 47B can have practical effect without creating federal private rights. It can operate defensively in state court lawsuits or other existing legal proceedings.
The government also argues that Oxford University Bank misread TAMA, because that case involves statutory language that Congress later removed from the Investment Company Act.
When the court hears oral arguments, what will you watch for?
I plan to laser in on how the justices react to the competing textual interpretations. Does rescission at the instance of any party create individual rights, or just describe judicial remedies?
I'm also interested in questions about TAMA's scope and relevance. The conservative justices might distinguish it as a relic from an earlier era when courts more freely implied private rights.
The practical workability questions could prove crucial. If Saba's interpretation would flood federal courts with investment fund disputes, the justices might prefer the SEC's exclusive enforcement model.
Watch for questions about state versus federal authority too. Investment funds organize under state law, but they face federal securities regulations. The justices might explore whether state courts provide adequate forums for these disputes.
The policy arguments could cut both ways. Some justices might worry about enabling short-term activism that hurts long-term investors, while others might focus on accountability for underperforming fund management. And given this court's emphasis on statutory text and structure, expect detailed parsing of Congress's choice to create explicit private rights in some Investment Company Act sections, but not others.
This case matters because it will determine whether activist investors get powerful new tools to challenge investment fund governance in federal court, or whether the SEC maintains primary enforcement authority over securities law violations. The decision will affect millions of Americans who invest in mutual funds, closed-end funds, and other investment companies. It could reshape the balance between investor activism and management stability in the fund industry.
More broadly, the case represents an important test of how the Supreme Court approaches implied private rights of action. A ruling for FS credit would reinforce the trend toward limiting private enforcement of federal statutes.
But a victory for Saba could signal renewed willingness to find private rights when statutory text and structure support them, even without explicit congressional authorization.
We'll definitely host oral arguments when they happen and analyze the eventual decision's implications for securities law and investor protection. Thanks for joining us for this deep dive into FS Credit versus Saba Capital Master Fund. It's a perfect example of how seemingly technical statutory interpretation questions can have enormous practical consequences. If you work in investment management, securities law, or corporate governance, we'd love to hear your thoughts on how this case might affect your practice.
In our next episode, we'll preview National Republican Senatorial Committee versus Federal Election Commission, a massively important finance case.
The National Republican Senatorial Committee seeks to invalidate campaign finance spending limits that restrict how much money party committees can spend in coordination with their candidates. This blockbuster case will hold profound ramifications for the midterm elections and presidential elections. We'll explain all of it tomorrow.
Thanks for listening to the High Court Report. If you enjoyed this analysis, please follow, rate, and share the podcast. You can also follow our LinkedIn page or send us an email with questions or comments. Talk to you soon.